Today, we're talking about a quiet revolution that has turned into a full-blown regulatory showdown. The prediction markets were supposed to be a clever experiment, and instead, they have forced Wall Street and state gambling regulators and the massive sports book industry into the same ring. And the fight is only getting louder. Cut through the noise and you see the simple question driving everything. When you list a contract tied to a sporting event on a federally regulated commodities exchange, what exactly is it? Is it a future? Is it a swap, a bet, or something entirely new? For the past year, courts and regulators have wrestled with that question. Kalshi versus Flaherty in New Jersey, Kalshi versus Martin in Maryland, and a case in Nevada involving the North American Derivatives Exchange. 3 courts, 3 approaches, and 3 different consensus. And while everyone keeps arguing preemption, the real story is happening in the background, and it's much bigger. These markets sit at the intersection of 2 powerful systems. On the one side, federal commodities regulation, on the other, state gambling law. And behind those systems sits 2 very different industries: the sports books with their state-by-state licenses, heavy compliance burdens, and large tax footprints, and the financial exchanges used to operating under structured national rules built for sophisticated instruments. So at the heart of the issue, do these products get regulated based on how they look to a retail user, or do we classify them based on how Congress defined futures, swaps, derivatives in the Commodity Exchange Act? Sportsbook operators love the duck test. If it looks like a sports bet and behaves like a sports bet, then regulate it as gambling. That sounds simple, but simplicity breaks down really fast in financial regulatory law. A total swap return mirrors a stock without being stock. A credit default swap tracks insolvency and risks without becoming a bond. Options provides protection without becoming insurance. Our regulatory system attaches to structure and statutory definition, not surface resemblance. And the prediction markets follow the same logic. The fact that they resemble wagers does not settle who regulates them. And Congress saw this coming. The Commodity Exchange Act explicitly contemplates event contracts. It gives the CFTC jurisdiction over swaps and futures traded on designated contract markets. It also gives the CFTC a narrow gatekeeper role for contracts that may involve gambling, terrorism, assassinations, or conduct contrary to public interest. This is a technical framework, and courts have been approaching it through different interpretive lenses so far. New Jersey looked at how Congress built the federal scheme. Maryland emphasized that the states still decide what counts as gambling. Nevada went textual, deciding that certain NFL-linked contracts didn't meet the statutory definition of a swap. 3 courts, 3 different viewpoints, no unified theory quite yet. But while this doctrinal question plays out, something else is already reshaping the space. In 2025, a new class action hit Kalshi in the Southern District of New York. The claim wasn't about whether the contracts were legal. Instead, plaintiffs argued that the platform misled retail users about who they were actually trading against. They thought it was other individuals, and according to the complaint, much of the liquidity on the platform comes from professional market makers with better infrastructure, wider position limits, and different fees. So this is a shift. Plaintiffs aren't fighting over classification in this case, they're fighting over mechanics, disclosures, counterparty visibility, market structure, and state regulators are lining up behind the same theory. Massachusetts filed a suit, New York issued a notice, Nevada, Illinois, and Ohio raised concerns about the risk profile of binary contracts. These actions lean heavily on consumer protection principles, and they don't require the state to win the gambling versus commodities fight. They simply argue that retail users deserve clarity and fairness and potentially aren't getting it. Meanwhile, institutional players are showing up in force. Quantitative firms, liquidity providers, even whispers of joint ventures involving Robinhood and other major firms and sports books, they see a looming threat. They operate under strict state licensing regimes, event contract exchanges operate under a federal regime with national reach and far lower barriers to entry and to scale. The economic tension is obvious, but again, economic resemblance doesn't decide legal outcome. We've always allowed financial instruments to mimic economics of other products without falling under the same rules. Prediction markets may be the next example. Courts will eventually clarify whether event contracts fall squarely within the CEA, but even after that happens, the operators who survive and scale will be the ones who proactively address market structure, transparency, clear disclosures potentially, better governance maybe, sophisticated surveillance tools, transparent rule books, more clarity about affiliated entities and liquidity providers. In other words, adopting norms long established in mature financial markets. Prediction markets have forced everyone into a conversation that was coming sooner or later. A conversation about how we regulate products that sit between two regimes, two industries and two philosophies. They're pushing regulators to rethink the line between financial contracts and wages. They're pulling institutional finance into a world historically controlled by state gambling frameworks, and they're challenging both sides to evolve in the process. Whether these platforms become the next major financial product or get boxed in as sports betting in some cases will depend not only on how courts rule, but on how well operators protect and inform retail users. Because once you blend sports, markets, and national scale, the scrutiny is inevitable. And this is the reckoning prediction markets have created, and it's only beginning. If you found this breakdown helpful, subscribe for more insight into the world of securities, commodities, fintech, and financial regulation. My name is Braeden Anderson. I'm a partner at Gesmer Updegrove. See you next time.